Welcome to our YouTube video series on class action lawsuits. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be providing some suggestions for prospective class members and actual class members when they become aware of a class action lawsuit that has a potential to impact them. Now, the first thing you should be doing is making yourself known to the class counsel. And what I mean by that is contact them, fill out any forms, make sure they are aware of who you are, what your current contact information is, and also keep track that they are constantly aware of any changes with respect to your contact information. Because all too often, class counsel is relying upon information that emanates from the corporate defendant. And the thing that the defendant wants to do is provide only the last known address, the last known email and phone number for all the individuals. Because if you don't have up-to-date information and one of the class members has now moved and can't be contacted, well, that means that person is unlikely to get anything. And it means that less money necessarily has to go out. So you don't want to rely upon the defendant to provide the contact information and keep your contact information up to date. Instead, you want to be proactive in this respect and make sure that class counsel knows what your current contact information is, and if there are any changes, to keep them apprised of it. The next thing you want to do is you want to collect and retain all information that could be of pertinence to the case and in relation to yourself. Because there is only so much information that is available to class counsel. Yes, the defendant is necessitated to provide information, but there might well be additional information, even beyond documentary information, that is of significance to yourself, your claim, and even possibly to the larger claim itself. And you want to be able to get that material collected and, where possible, provide it to class counsel so that they can further substantiate their position and further substantiate the strength of their claim, which is your claim, and move it forward. Remember, you're providing information that is beneficial to yourself. You're not going to be charged necessarily for this. It's not really a charging process. Most class counsel are undertaking these things on a contingency basis, if not all the time. So that means they're going to get a percentage of whatever is recovered as determined by the court. And with that being said, if they're going to be getting a percentage, and it's a standardized process, you're better off making sure that the class counsel wins, that all the plaintiffs and the class members win, because when they win, you're winning. So you want to do whatever is possible, in my professional estimation, to strengthen that case. And oftentimes there are particulars that are needing to be determined with respect to your individual claim within the class claim, because oftentimes there's information that either the defendant doesn't produce or the defendant has limited access to, so that their calculation relative to what your calculation should be needs to be determined based on additional information that you provide and supplement to the class counsel. But there's another aspect that goes into this, because all too often what people do is they just sit back and they allow the process to go forward. And in certain cases that might be appropriate. So let's say there's technical glitches with some technology and everybody's going to get paid out based on that. There might not be much in the way of an individual claim. Nevertheless, if you look at most Canadian legislation with respect to class action lawsuits, there is a level beyond the class claim level, beyond the subclass claim level, and there is an individual claim level. And especially when it comes to employment cases, you can see how, whereas there are larger class claims, there are the potential for interrelated individual claims. And those individual claims are adjudicated after the class claims are adjudicated, but they are potentially tied in. And this is the critical thing that you have to understand, is that whereas you might not have undertaken an individual claim previously because you were not fully apprised of it, not aware that you might have an individual claim, or you couldn't afford that individual claim, within the class proceedings, there is all too often a mechanism available to have this matter adjudicated. And if you choose not to adjudicate it, that's fine. But if the procedure is put in there and it's available to yourself, it is something that you should look into. It is something that you should talk to class counsel and make them aware of it. Because once again, you're in a brand new procedure. And if you've gone through the class aspect, and more likely than not, it has been successful such that you move on to the individual aspect, the defendant corporation is put in a very difficult position in that they need to resolve the matters. And the court has already determined that there are significant issues that are problematic in which there need to be settled, resolved, or litigated. And that does not bode well for the defendant corporation, in the sense that if it's been established at the class claim and subclass claim level that they have breached their obligations, they have breached contracts, they have breached statutes, this translates and impacts other aspects. And those other aspects may be individual, in the sense that the fact that you had signed off on documentation but had been misrepresented to as to the rationale for it, and had stuff improperly prepared and submitted to you by the defendant corporation in your individual capacity, may well lead you to have the ability to pursue an individual claim as against that party. You really should consider the possibility that you might have an individualized claim as against a defendant, depending on the form of the class action lawsuit. And now you're being given an opportunity to pursue that claim. And unlike other scenarios where taking on a single separate claim against that particular defendant is somewhat more challenging, within the context of a class claim, where you take an individual claim, you have counsel that is already very familiar with the action, and typically, depending on the size of the individual claim, there is going to be a structure within which that matter can be properly adjudicated. And given that structure, it is that much more efficient for class counsel to undertake these individualized representations within the framework of the class action lawsuit, and thereby continue on a contingency arrangement of a different form to provide counsel and to aggressively pursue that action in a very efficient manner. Because now it is just a small segmented part of a larger court proceeding, a larger legal proceeding that you're operating under. And class counsel is extremely familiar with a lot of the issues or the interrelated issues, and this is just one step further on, as opposed to getting brand new counsel, which you're perfectly entitled to do or perfectly entitled to discuss with and maybe see if they want to undertake the individual part of it. But you have these different avenues that you should be looking at and determining whether it's with class counsel or your own individual counsel to see if there's something more. Because typically people are not going to want to opt out of the action. They'll let the class, and they should look at it from that perspective to see, even if they have their individual claim pursued by another lawyer, they may well want to allow the class counsel to continue to do the work, because when class counsel is doing the work, as a class member, you're only paying them a contingency based on their success, which is in many respects advantageous to most people because they don't have to assume any of the risk or any of the cost associated with pursuing a particular defendant. Naturally, if your claims are substantial and they're very different, there may be a rationale for opting out. But in most circumstances, opting out tends not to be the appropriate form. But remaining within the class and remaining a class member doesn't mean and should not mean that you simply sit back and wait for something to happen. Instead, you should be somewhat proactive, because oftentimes there's a lot more to the claims, especially the individual claims, but even the class claims, than you could imagine. And when you find out what you can contribute, what you can provide by the way of documentation to class counsel to advance the class part of it, and what may also be available on an individual level, you could be somewhat astonished as to what might come out of this. And you got to remember, this is all being undertaken largely in contingency, so you're not advancing funds. You're not overly committed to anything other than if you engage class counsel or your own lawyer to pursue the individual claims, you have to commit to them. But otherwise, they're undertaking the work and you're hopefully going to get the benefits, and your engagement, your contribution will hopefully increase the amount of benefit, the amount of award that you're going to be receiving from this particular class action. So you can't just sit idly by. Keep yourself familiarized with what's happening in the class action, and to the extent that you can contribute by way of information, documentation, input, you should really be looking at that because it only serves your best interests. And especially with so much information available, you should be looking to keep yourself apprised, because as new things develop, even in the claim, you might be saying, whoa, something new has arisen. I hadn't thought about this before. Class counsel might have only come across it recently, but this impacts me, and maybe there's something more for myself. So you should be engaging with class counsel or engaging with your own lawyers to make sure that you are up to speed and they are up to speed as to what you have available to them. And that is how you benefit most from participating and keeping yourself in a proactive stance with respect to a class action lawsuit that you're either a prospective class member of or you're an actual class member of. And hopefully that has provided you some guidance as to how you can get the most out of being in a class action lawsuit. Thank you.